Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. And this morning, on this beautiful summer's day, I'm recording a review of a book that's come into us from Intersentia, who are an important legal publishing firm based in Cambridge in UK and in Antwerp. The book is called Andrews on Civil Processes. It's now in a second edition and it has the subtitle Court Proceedings, Arbitration and Mediation. Now, the book's an important book for a lot of reasons. One is it's one of the main books, I think, which Intersentia publish. It's one of their very substantial works, which will be of relevance to a very large number of people. And secondly, the whole issue of mediation is coming to the fore at the moment with major changes for 2020. I, of course, am a practicing barrister at law and a mediator, and I'm the book reviews editor of the Barrister magazine. And my purpose with this particular presentation is to tell you a little bit about the book. I've given the title of our review an important statement of law on the main forms of dispute resolution today. Let's have a look at the book. There it is, there's the front of it. You can see the front page quite clearly. And then you can see the spine. There's nothing on the back. It's a very heavy book, it's a hardback. Neil Andrews is the author of it, Professor Neil Andrews. Let's go to the back of the book first of all. There's a little bit of detail about Neil right at the back. Professor of Civil Justice and Private Law, University of Cambridge. Apart from many other things. The index is by paragraph numbering. You can see it there probably reasonably clearly. And it's a detailed index, which is of great use. You should be able to find everything you're actually looking for. There's the front of the index there. Then, of course, we've got a bibliography, very substantial. This is a very detailed work. It's not in any way for beginners. That's the back of the book. Let's go to the front of the book next. This is the front page. There's the front page there. Then after that you have a dedication. And the reason I always point out the dedication is a lot of people are involved in these works. And we only review books which we think are important. There's no point in reviewing a book where we're going to be critical of it because, frankly, it's not in anyone's interest at all, for the profession anyway, and for the wider academic readership. That's the preface. Do read it. The preface is dated 8th of February 2019. And I'll talk a little bit about the law and where it stands in a moment. There's the contents section, quite detailed all the way through. You can see it's split into various parts. Mediation comes towards the end with arbitration. And then what we do right at the back is we have the last part of the contents section, and the last chapter is chapter 43, which deals with foreign awards. And we've then got the tables of cases, a very substantial number, and running through the table of cases we then get to the table of statutes, and then after that statutory instruments, naturally. And then after that, we're almost there, we get to what is a very useful, these pages are quite thin by the way, very useful list of abbreviations. I do think with dispute resolution it's important to know what the abbreviations are because there are quite a lot of them and they're quite useful too because one does forget. Then you see the beginning of the book, part 1, the introduction to the forms of civil justice. Then you see the structure of the book itself. We get an overview, so that's an introduction and then an overview, which is quite useful to start with. And then you get to the paragraph numbering, which you can see, which is on the side there, and you've got footnoting all the way through. And just going into the middle of the book, this is about privileges. You can see again the detail. As I say, it's a very important work, and one of the leading works in its own right, in my view. So it's a very hot day today, so you can probably gather I'm sweating a bit. What do we say about the book? Because it's a long review, and this review has appeared in the journals. I say this, it's always the case that the legal publishing firm Intersentia, based in Cambridge, Antwerp and Chicago, delivers the legal goods for the legal profession. And they do so in spades here, with this authoritative statement offering a fresh and stimulating examination of civil justice, embracing court proceedings, mediation and arbitration. And as I say, I'm involved specifically in both court proceedings and mediation, and they are basically what we are calling for this purpose civil processes, because I'm dealing with the civil law. The book's been written by Professor Neil Andrews from the University of Cambridge, and it's a new edition which has been summed up brilliantly in this way: a critical and principled treatment of the subject made possible by extensive knowledge not only in English methods and techniques but also in foreign civil procedural laws. I think that's important to bear in mind. The foreign stuff is at the back, but to us this new edition remains one of the most important books which Intersentia published, and it contains both national and comparative law advice for all practitioners. It's a substantial volume, and Andrews guides the reader through the practice of dispute resolution in all its major forms for this new second edition at a time of change. Now, the book came out in 2019, and we're looking at changes coming in 2020 onwards. And what the author does is he covers public and private, adjudicative and conciliatory methods in thorough detail. Now, obviously, adjudication and conciliation and mediation are particular terms, but we embrace them all for the term dispute resolution. The ensuing 1,200 odd pages give both lawyers and laymen alike a complete picture of the court and arbitration systems and the developing technique of mediation, as I say, at a time of substantial implementation in the 2020s, when without doubt we consider that Andrews on civil processes gives many of us what we've been looking for, that is, an outward-looking work. We as advisors, of course, seek further leads, and we've got them here because we've given additional assistance with the detailed citations of primary sources and the rich biographical references to national and foreign works. Again, you'll find those at the back of the book. And it makes the work heavy, of course, in all senses of the word. Now, Andrews on civil processes has developed into an authoritative statement on the fundamental and systematic treatment of its subject by its leading expert, that is Andrews. And he offers us an acute observation in the preface of why this book has now appeared in a new edition by stating, quote, that universities and the legal profession and judiciary must continue to work together in the common cause of supplying a rich education and achieving a critical perspective on legal practice. And I'd go further, it's PLE, it's public legal education. It's something that we've really got to spend much more time on as the electorate becomes, and the public become much more knowledgeable. And therefore it goes without saying that this book will provide a valuable resource on the changing civil processes we face in the next decade. The work's been fully revised and updated for the second edition, and it remains an essential work of reference for litigation advisors, judges, commentators, and students, of course, people who are beginning to look at this subject area in more detail. And I'd like to thank people running the bar vocational course, whatever it's now called, because it's changing again, because they're actually having much more emphasis placed now on mediation and dispute resolution, which hitherto when I did the course we just didn't have. And of course we do make special reference here to the increasing support the courts give now to mediation and to arbitration, as both are nearly always selected as an alternative to the court processes. And of course we will be entering an era shortly where there will be mandatory mediation in many cases. And as many non-resident participants now choose to conduct arbitration in London, that's in central London, or bring proceedings before the English High Court, particularly the commercial court, we're given the clear and well-ordered structure of Andrews on civil processes to assist us, obviously coming from the publishers Intersentia. And we feel that the book will also be of interest to the lawyers beyond just the jurisdiction of England and Wales to cover non-English practice. Now, the second edition of this hardback book was first published on the 26th of April 2019, and the author states that he sent his manuscript to Intersentia based on the weekly law report, case law reports, no later than the 4th of May 2018. Now, therefore, what Professor Andrews is saying is that it's been possible to make, since that date, changes to reflect developments which have emerged before March 2019. So it's very up to date, and we therefore have this very up-to-date statement, as I say, whilst we prepare for further changes to the civil processes in 2020 and beyond. And as I say, I think this book is a particularly important book. Let's just have a look at it again. There's the front. It's Andrews on Civil Processes, the front. As I say, it's a heavy book. And then the spine, there's nothing on the back of the spine. Just opening it in the middle, you can see we're looking at general cost rules here. Costs being the bane of many people's lives. It's always, and you can see the structure of the book again, the paragraph numbering, and of course the footnoting. Altogether, I think it's a first-class book. I was delighted to be invited to review this work. Thank you very much to everybody who's been involved in it, and I hope it assists you with whatever type of dispute resolution you're involved with. Thank you to all. Bye-bye.